Hello there. My name is Scott Shalene, and today I'm going to be speaking with you about something very exciting. Compensation for injuries in commercial aviation accidents, something we all love to think about. So we are going to look at how the law is currently in Australia and how it's governed internationally. We're going to look at issues with the law and how it can be reformed, specifically with regards to psychiatric injuries. But first, I want to start by telling you a story. It was July 25th, 2008, and there was a flight on Qantas Flight 30, that was going from London to Melbourne. Now, in the industry, we call this the kangaroo route, going from the UK all the way to Eastern Australia. And with the type of aircraft we use these days, they're not able to do that all in one sitting. They have to make a fuel stop somewhere in Asia. And prior to COVID, Hong Kong was a very popular place for the refuel. You basically, go to the airport, refuel for about an hour, hour and a half, take off, be on your way. Now, this flight from Heathrow to Melbourne was on a Boeing 747-400. It had 346 passengers and 19 crew. And the first segment from Heathrow to Hong Kong went without incident. But the second segment, just over an hour or about an hour after departing Hong Kong, the passengers heard a loud bang. Not something you want to hear when you're flying. And immediately the cabin depressurized. And there was a hole in the floor of the passenger deck that appeared, and parts of the aircraft ceiling and floor actually collapsed. And immediately after this happened, the plane started rapidly descending. Now, in this emergency descent, they went from 29,000 feet near cruising altitude to 10,000 feet, the altitude at which the cabin is typically pressurized, in less than 7 minutes, which is an astoundingly fast rate of descent. And miraculously, thanks to the pilot's skill, they were able to make an emergency landing in Manila without one fatality and without one injury. No one was physically injured during this accident. However, as you know from any safety briefing on any commercial aircraft, in the event of an emergency, oxygen masks will drop from the ceiling. Well, of the 346 passengers, 4 of them, that did not happen properly. Their oxygen masks did not drop down. And as the aircraft was descending in such a way, they had difficulty breathing, a very, very traumatic experience. Here, you can see a photo of the actual damage, the big hole in the cargo hold that was due to this oxygen tank that exploded. It must have been really fun sitting in that exit row right above it. But the lessons from Qantas Flight 30 are, one is the improved technology and pilot training have made commercial aviation safer, and that is a great thing. It also showed that it is possible for there to be an accident without any physical injuries. Now, it might seem obvious, but that's important for what we're going to be talking about. But I want you to think about the perspective of the 4 passengers for a minute who were deprived of oxygen momentarily due to their oxygen masks not deploying properly. Now, is it possible an experience like that might result in psychiatric injury? Of course. But how can the law remedy this? Now, it should be said that aviation is by far the safest way to travel. And commercial aviation and the invention of the aircraft is one of the most revolutionary developments of the 20th century. It's revolutionized commerce, trade, medicine, warfare. It's made the world smaller. I don't know what the world would be like without it. But the aviation industry is so safe because it is so heavily regulated. There's standard operating procedures, everything's standardized. There's high barriers to entry for operators, and there is extensive training involved to become a pilot. And coupled with the technology over the years has improved, Aviation has never been safer than it is today. Even still, on very rare occasions, accidents and incidents do occur that result in everything from minor to serious to even sometimes fatal injuries. And those are compensable under the law. But what about psychiatric injuries? What if one of those passengers that didn't get their oxygen mask suffered from PTSD? Well, that's what we're going to be addressing today. The interest group that I am advocating on behalf of are domestic airline passengers in Australia. Now, this does not include airline passengers on international flights because international flights are governed outside of the scope of Australian law. They are governed by a treaty known as the Montreal Convention, which over 120 countries are signatories to. So we're going to focus solely on domestic flights here. And the goal is to balance the interests of domestic airline passengers who suffer from pure psychiatric injuries that result from the accident with the interests of airlines, insurers, and other passengers and employees in the industry. And the policy goal of this all is to enable compensation for victims while curbing costs and preventing something known as a floodgate issue, which we'll cover. Now, the area of personal injury I'm focusing on are pure psychiatric injuries that result from commercial aviation accidents, because the current law actually has a remedy for psychiatric injuries that are tied to physical injuries. But that's the catch. It has to be tied to a physical injury. The focus on psychiatric injuries that are not tied to physical injuries is where there's a gap in the law, and that's what we're going to be covering. Now, the why behind this is currently, if you suffer a diagnosable psychiatric disorder or injury that can be attributed to an aviation accident, but have suffered no physical injury, you are not entitled to any compensation under Australian law or international law for that matter. And you're not able to get it under Australian law because Australian law is based off of international law. And we know, from a medical perspective, it is possible to suffer a medically diagnosable psychiatric injury triggered by a traumatic event without suffering a physical injury. Being physically injured is no precondition to anxiety, PTSD, depressive disorder, or any of those types of ailments. And with psychiatric injuries, there are real costs associated. So to prevent a floodgate issue, though, on the flip side of this, any reform that we do must be narrowly tailored in scope. And we're going to explore how we can possibly do that. Now, to address the floodgate issue and the scope of this, how this works in terms of compensation is all airlines are required to carry two things. One is a valid AOC, or aircraft operator certificate, and the other is a COI, as we call, or a certificate of insurance, which is third-party liability insurance, and that insurance covers injury claims of passengers. But if we were to open up the floodgates to claims of pure psychiatric injury, the result could be that costs skyrocket for this insurance. And that cost is passed along in the form of higher ticket prices, possibly employment of airline employees that are infected. And you have a whole host of negative externalities that makes the cure worse than the disease. You could have the example of frivolous claims, like people might have turbulence on a flight, routine turbulence that you should expect as a regular thing. And now I have bad dreams and I want to sue for compensation, and that could clog the courts. And then there's also legitimate claims on an overwhelming scope. Think of the September 11th attacks in the United States, when millions of people witnessed on live TV those attacks, and many suffered from pretty serious psychiatric injury because of that. It was a traumatic thing to witness. Now, could someone who watched that on TV in real time that was in Texas or California sue American Airlines and United for that? Well, you could see the problem if we would let them, if that was, part of the scope. So we have to narrow this in scope. And because of this, case law throughout history has been understandably reluctant to open the doors to compensation for psychiatric injuries without a corresponding physical injury. Now, statistically, aviation, like I said, is the safest way to travel. You're safer getting on a plane than you are getting in an Uber. In 2019, and we're using 2019 because that was the year before the pandemic, when it was probably most normal, there were no fatalities with commercial air transport in Australia. There were 220 accidents, but those were largely recreational and general aviation accidents, not something that happened on commercial airlines. But that doesn't mean that that is not an occurrence. It happens in other countries all the time. So we need to tailor the law around addressing that. Now, let's get into the history of psychiatric injury when it comes to case law. The floodgate issue that I mentioned has been a concern from the beginning, that fear of a slippery slope. And it first borne out in Australia in this case called the Victorian Railway Commissioners and Coultas in 1888. And this was a claim for a pure psychiatric injury by a woman who was in a carriage and she was crossing a railroad track. And the guy who lets the bar thing up and lets them cross did it at the wrong time. They almost collided with the train. She thought she was going to die. She suffered severe psychiatric injury due to it, allegedly, but didn't suffer any physical injury. She claimed that she suffered a miscarriage ultimately because of the stress that this had her endure. But when this went to court, it failed in the Privy Council on the grounds that the psychiatric damage could not be proven, that it's too remote of a consequence for tortious action, and as a matter of policy, it would create a slippery slope leading to imaginary claims. And the establishment, this has set the precedent of the establishment of liability faces higher hurdles than physical injury does. And that's for obvious reasons. It's harder to prove that you have PTSD than it is to prove you have a broken leg. But societal attitudes on mental health have played a role in shaping this doctrine over history, and medical science on mental health has evolved over history. So this is a case of the law should keep up with the science. And there's also this notion that the effects of mental injury are often harder to measure than physical injury. And that's true even today. But the traditional notions of psychiatric injuries being hysterical and irrational and somehow less worthy of compensation than physical injury is simply not something that the medical science, agrees with today. These things come with real costs. So how do you balance this? The floodgate concerns for a potential of a vast number of claimants, like where do you cap this? And historically, it's been limited even in very famous cases. Most notably, during right after the 9/11 attacks, there was a 9/11 victims compensation fund that was a $7 billion fund that went to those who were injured and the families of those who were killed in the terror attacks. And they set a rule that they will not give compensation to anybody who suffers a pure psychiatric injury. You need to have an injury for that. So if you were injured in those attacks, you have a claim. If a loved one was murdered or killed in those attacks, you have a claim. If you escaped from the World Trade Center, maybe saw someone jump out a window, saw people die in front of you, were severely traumatized from that and suffered because of that, you weren't able to get any compensation. And the reason for that is if we compensated every person who suffered a traumatic mental injury from those attacks, that would come at the expense of compensating, the loved ones of those who were killed and those who were physically injured. And so you had to draw a line somewhere there. Now, the current law is governed by the Montreal Convention for international flights. And that was incorporated into Australian law by the Civil Aviation Carriers Liability Act of 1959, or more specifically, an update to that, an amendment to that, that took place in 2012. So currently today, injury or death is compensable up to about 925,000 AUD in a no-fault strict liability compensation scheme, which means that passengers who are injured do not have to prove fault, they just have to prove injury. And psychiatric injuries are not compensable unless they are tied to a physical injury. And one interesting note is the language in the Civil Aviation Act was changed from personal injury to bodily injury in 2012 to mirror the language in Montreal. And why that is interesting is bodily injury is often far narrower in scope than personal injury when it comes to tort law. An example is in Queensland's Civil Liability Act. The definition of personal injury includes psychiatric injury. Now, to start with the liability, the carrier liability, this is a strict liability on a carrier for bodily injury sustained by a passenger, which is caused by an accident. And there's a limit on the damages under this no-fault scheme. As of 2022, it's 925,000, which that was amended, I believe, in 2020. And that's actually higher than the standards set in Montreal, which is an important point on how Montreal is in fact a floor, not a ceiling. And we should look at that as that from a policy perspective. Now, if a claimant wants to claim damages beyond the statutory limit, Article 21 in Montreal provides that a carrier will not be liable if it can prove that the damage is not due to the negligent acts of the carrier or its agent, or if they can prove that the damage was solely due to the negligent acts of a third party. But most people who make claims get it under the Montreal or the civil aviation law protocol, because the amount of compensation you get from that is typically higher than if you were to litigate it. Now, the duty of care is laid out in Article 17.1 of the Montreal Convention, which is also incorporated in the Civil Aviation Carriers Liability Act in Section 9E. And you can see there highlighted, that's the actual language of the act, anything that takes place, any injury that takes place on board the aircraft or in the course of any operations of embarking or disembarking. You don't need to be flying, you don't need to be taxiing, the aircraft can be still. You are within the duty of care per Montreal standards during those, during that window, embarkation, on board, disembarkation. Now, to understand what a breach would be for a carrier, first we have to understand what is an accident. And for this, we look at the International Civil Aviation Organization, which has this thing called Annex 13. And Annex 13 is a way of how they investigate accidents and incidents. Now, an accident is defined as an occurrence involving an aircraft where a person is fatally or seriously injured, or an incident where the aircraft sustains damage or structural failure, or if the aircraft is missing or inaccessible. Notice the third one would cover an instance like Malaysian 370, which has not been recovered to date, but is accepted as an accident and hull loss. An incident is an occurrence other than an accident that could affect the safety of the operation. And within the scope of incidents are serious incidents, which involve circumstances indicating that an accident nearly occurred. And that's determined by the investigation that takes place. It's said that Annex 13's sole objective is to generate safety data and prevent future accidents and incidents, not to apportion blame or liability. And while that is true, you can still determine and really see where the breach occurred based on the findings of these investigations. And breaches of most civil aviation rules are considered offenses of strict liability. Now, for causation, as we said, Annex 13 investigations, will determine the cause of the accident and incidents. But this thing called the Damage by Aircraft Act limits the liability of a carrier if the injured party engaged in negligent acts. And that happened as well in the 2012 reforms. And damages, as we've discussed, The level of damages, the floor of it is set out in Montreal, but the reforms that Australia put in place in 2012 and subsequently in 2020, where they raised it from 500,000 to 725,000, and now it's 925,000. It's indexed, due to the rising cost of living and inflation. And in fact, there's no regular indexation of it. It has to be changed legislatively by Parliament, but having some sort of formula for indexation might be a decent idea for reform. And like I said, with strict liability with a carrier, the plaintiff does not have to prove fault, just to prove an amount, and that amount is ultimately determined by the courts. Now, the Civil Aviation Carriers Liability Act, Section 9E, provides that Montreal replaces any other civil liability of the carrier in respect to personal injury that has not resulted in the death of the passenger. And it's currently mirrored in Australian law. Now, bodily injury case law. Bodily injury in terms of aviation law originates in the Warsaw Convention of 1929, which predated the Montreal Convention. The Montreal Convention replaced Warsaw 70 years later. And there are international cases, such as in the US Supreme Court, Eastern Airlines v. Floyd, which decided that bodily injury does not include purely psychiatric injuries. But Floyd left open the question of whether bodily injury included psychiatric injuries accompanying physical injuries. And subsequent court cases determined that, yes, it does, but the scope of that has been debated. And it was most recently litigated in the Pell-Air and Casey case, which we'll discuss. So the Pell-Air case was an air ambulance flight that was chartered from Samoa to Melbourne, and it had 6 passengers. And air ambulance flights, I've done a lot of these before, they're almost always at odd hours of the day. Urgency and time is of the essence. And this flight was no exception. So it was, flying at night. And it was on a light jet that could not fly from Samoa to Melbourne in one stop. So much like the kangaroo route, it had to make a stop on the way. And this was in Norfolk Island. Now, there was inclement weather, there were storms, and this plane made 4 attempts at a landing, but had to abort every time. And it did not have enough fuel to divert to any other airport. So ultimately, the pilots made a decision that they have to put the plane down in the ocean. And they did so, and miraculously, all of the passengers survived, but a couple were injured pretty severely, including Miss Karen Casey, who was the in-flight nurse. Now, they all survived, but they were out in the water at night for 90 minutes before being rescued. And Karen Casey not only suffered physical injuries that resulted in chronic pain, but also that included severe psychiatric injuries, including PTSD, anxiety, and depression disorder. And she, sued for compensation under the argument that the personal injury in the Civil Aviation Act and under Montreal would cover her psychiatric injuries. And originally the courts agreed with her, but when it was appealed to the High Court, it restricted it a bit. It said that the Section 9E does not confer compensation rights for personal injury, and compensation rights under Part 1A of the Act are restricted to damages for bodily injury in accordance with Article 17.1 of Montreal. So the court's saying that the Civil Aviation Carriers Liability Act and Montreal, there's no real daylight between them when it comes to bodily injury. They held that bodily injury includes psychiatric injury, including PTSD, when it is caused by a physical injury or proven on the evidence to be a species of bodily injury in its own right, like brain damage, for example. Now, the issues with the current law, as I've said, is this precludes compensation for any psychiatric injuries that are not linked to physical injuries. And it's medically possible to get a psychiatric injury without a physical injury. So how do we allow recourse for victims of pure psychiatric injury without opening the floodgates? And how do we reasonably limit the scope? Well, the concerns for expanding the scope, you have to ask, what constitutes psychiatric injury? What is the scope of duty of care with respect to the carrier? How do we prevent a floodgate issue of frivolous claims? are people who are not passengers entitled to compensation? How is the level of compensable damages measured? And what effects and externalities would this have on insurance prices and the cost of business for the airlines and the insurance companies? Well, my idea for legislative reform on this would be to limit the scope to only passengers within the duty of care outlined in 17.1 of the Montreal Convention. And so it has to be an actual accident per Annex 13 standards. It has to be a diagnosable psychiatric injury or disorder primarily caused by the incident. And it has to be, this diagnosis has to be affirmed by 2 licensed medical professionals in Australia. And if all these criteria are met, that passenger with a psychiatric injury would be subject to the same compensation limits that as a bodily injury in Section 17.1 of the Civil Aviation Carriers Liability Act. It would be determined by the courts on what a fair compensation would be. Now, the effects of this reform is it would protect carriers and insurance companies from significantly increased costs and liability due to the restricted scope of claims. You could say, well, why don't they just, litigate that in court if their claims are so strong and the bar is so high? The reason is this reform would make it easier and quicker for them to get compensation. It would still provide a recourse for legitimate claims of victims of pure psychiatric injury while walling off the non-serious claims. Because we should think of the Montreal Protocol as a floor, not a ceiling. Australian domestic carriers can still provide a greater degree of protection for passengers. Just because the standard for international flights is lower, because we had to get 120 countries to agree on it, does not mean we should limit the rights of Australians on domestic flights. And this is, in the spirit of tort theory and the principle of full compensation in tort law, where it's putting the victim in the position they were before the tort. It also, to a degree, is relevant for compensation deterrence theory, because this makes incentives for carriers to make an already safe mode of travel even safer. And ultimately, this is a reform that does not close off legitimate victims who have a claim of a pure psychiatric injury, but it still protects the airline. It protects insurance companies and rates from skyrocketing, and it protects passengers. It's a very conservative reform, but it is one where we are making the law catch up to the medical science. And that is my idea for how Australian domestic flights can be remedied when there are accidents that result in such psychiatric injuries. Thank you.